This conference will now be recorded.
All right, hello and welcome everyone to Oceanside Library's Estate Planning 101. I'd now like to introduce our presenters for tonight, Christy and Leslie. Take it away.
Good evening. Welcome. Welcome to Estate Planning 101. The outbreak of COVID-19 represents a threat both to our physical and our emotional well-being. It reminds us that we live in an uncertain world. Proper planning allows us to take control of our personal and our financial affairs now and in the future. In a time like this, planning is more important than ever before. Having the documents in place and understanding what an estate plan is ever more important now. We're going to present Christy DiPaolo. She is the estate planning attorney who will start off the meeting talking about estate planning.
Hi, everyone, and thank you for being patient with my technical difficulty. My name is Christy DiPaolo. I'm an associate attorney at Berwitz and Ditata. We are an estate planning and elder law firm. We do all aspects of estate planning, estate litigation, Medicaid planning, applications, special needs planning, and guardianship. So I'm going to just talk to you a little bit about why and when you should do an estate plan, and Leslie's going to talk about some tools that she can help you with in your estate planning process. So when should estate planning begin? Well, how many people are affected by illness or incapacity? Over 52% of us will need long-term care at some point in the future. So what's the likelihood it'll happen to me or my loved one? Pretty likely. Who will make decisions for me? And can I maintain control? These are some of the things you want to think about before you start to create your estate plan. So what does estate planning entail? Well, are you healthy and independent? Are you married and you and your spouse are both healthy and independent? Are one of you ill? Has one of you passed away? Or are both of you ill or in precarious health? Well, how do we begin? You want to first think about who are your loved ones? Am I married? If so, is this my first marriage? Or is this a second marriage for me? If I'm not married, do I have a long-term partner that I've been with for a very long time? Do my loved ones have any special needs? Do I have anybody who has a disability or is incapacitated? Do I have minor grandchildren or children? Are my beneficiaries disabled or elderly? Do I have pets that I want to plan for? You also want to think about what are your assets? Do I own property? If so, where is it located? Is it in New York? Do I have property out of state, out of the country? Do I have bank accounts, investments, retirement accounts? Do I have insurance? Do I own a business? What are my goals? Do I want to protect assets for my own benefit, for my future, if I were to become ill and pay for my care, or the benefit of my spouse, partner, or other loved ones? Do I want to leave assets for my children and grandchildren? Do I have a loved one with special needs? And will my estate be taxable? That's something you want to think about when you're planning, and certain planning can help reduce your estate taxes. Currently, the New York state tax exclusion is $5,850,000. The federal is $11,580. Those are significantly high numbers currently, but if you have assets that come close to that, that's another thing you want to think about when you're doing your planning. You want to think about who can carry out your wishes. Who do you trust? Who do you want to make sure your estate plan is followed? If you create a trust, how long will that last and continue after my incapacity or death? Will anyone contest my wishes? Do I have a relative or a strange family member that I may not want to include in my estate plan, but may contest later on? So what are some of the tools and first steps we should think about when doing estate planning? Well, One of the things is a power of attorney. A power of attorney is a document that enables you to appoint an agent to make decisions for you affecting money and property. This is probably one of the most important documents you should have. And at 18 years old, I would recommend you have a power of attorney in place. What this does is authorizes someone to act on your behalf in the event you're incapacitated or ill and can't get to it, and they can act for you currently when the power of attorney is signed. We have a client who was a young person, and they became ill at 42 years old. They had an asthma attack, became incapacitated. They were young, didn't think they needed to do estate planning, and because they hadn't done the planning, there was nobody able to access their assets, their accounts, or act on their behalf in regard to money and finances. The family had to petition to the court to have a guardian appointed, which is very costly, time-consuming, and then there's court oversight involved. So a power of attorney is something that someone at 18 years old or over can sign, and it is recommended so that you have something in place in the event you become sick or ill unexpectedly. Healthcare proxy. This is another document that's very important. This designates a medical decision maker. This is someone that can carry out your healthcare wishes in the event you can't speak for yourself. Now, if a doctor can talk to you and you can make your own health decisions, they're going to listen to you first. But this document designates someone to speak when you can't. If you are unconscious, if you are unable to speak, you would have a conversation with your healthcare proxy, let them know your wishes, and they could speak on your behalf with doctors. Another document is a living will. This is a document that contains specific instructions concerning your end-of-life and healthcare decisions, and it's primarily used in the event your healthcare proxy is not available or if you're outside of New York State. Another important document is a last will and testament. So why is a last will and testament so important? Well, this is the only way you can designate guardians for minor children. You can name a guardian in your will if you have minor children and someone that you trust and know to take care of your children. If you do not have this and something happened to you, someone would have to petition to the court to have a guardian appointed for your children, which could be someone that maybe you wouldn't want. A will also effectuates the transfer after death of property titled in the name of the decedent, which is the person who passes away. If you don't have a will, your estate passes to heirs in accordance with law. Now, this also may necessarily not be what you wanted. In New York, if you die and you have a child or children and a spouse, they are your heirs in accordance with law. Everything doesn't go directly to your spouse. Your children get a share of your estate. But a will is only effective after death. It only kicks in once you pass away. And a will must be probated in court to take effect. So you can create a will once you pass. Someone has to petition to the court to have your will filed and to be probated. This process can be time-consuming and costly sometimes. And it's not private. The surrogate's file is public record. So what is probate? What does it mean when you probate a will? Probate is the legal process that is required to prove the validity of a will, a last will and testament. It settles the affairs of the decedent's estate, and it resolves claims of creditors to the estate. It can adjudicate the interests of heirs and other parties to the estate, and it allows you to transfer assets or retitle them in accordance with the terms of the will. Another document to create is a trust. And a trust is different from a will because it's a legal arrangement in which the manager, also known as the trustee, controls the money or property for the benefit of one or more beneficiaries. It starts with a written agreement between the creator of the trust, which is the grantor, and the trustee. The grantor then delivers the assets to the trustee to hold and use for the benefit of the beneficiary. So I can create a trust during my lifetime, establish a trustee, fund the trust, and it can be used for the benefit of me or other beneficiaries. The written trust agreement specifies the rules. So are there advantages to using trusts in estate planning? Well, yes, there's lifetime advantages. You as the grantor, the creator, maintain control and direct the manner in which the assets are to be used, invested, or managed. It's an effective tool for unification of accounts and assets because you can retitle all your multiple accounts and assets into the trust and it's managed under one entity. It provides a succession plan, a successor trustee, and successor beneficiaries. And it can provide specific protection for minor or disabled beneficiaries or those with other special needs. You can create sub-trusts in your trust that will protect money for the benefit of beneficiaries. For example, if you have somebody who's receiving Medicaid or other state benefits, you can have money available for their care, but not available to them so they don't lose their benefits. There are also post-death advantages to using trust. Like a will, a trust effectuates the distribution after death of the property titled in it. But it allows for ease of administration. It's less costly and time-consuming. You don't have to petition to the court to have a trust approved. It avoids probate. There's no court proceeding. The trustee can act. It also avoids ancillary probate. What this means is if you own property in more than one state, you have to do 2 probates unless you use something like a trust and title all the assets into that trust. The assets are immediately accessible to the successor trustee. So unlike a will, once the will, the assets can't be touched until an executor is appointed and the will is probated. A trust can be accessed immediately upon the grantor's passing. It also maintains privacy. A trust is not public record. It's not filed with the court. So the type of trust I was just talking about is a living trust. It's revocable. They can also be modified during your lifetime and can be changed anytime you wish until the point you become incapacitated or die. There are also other types of trusts that you can create, which are called irrevocable or Medicaid trusts. So what is Medicaid? Well, Medicaid is a joint federal state program which is administered by local governments. It's means tested and needs based, and there's limitations on income and resources. The federal government sets up the guidelines and each state designs their own rules. It pays for long-term care that's not covered by health insurance. So there are only 3 ways to pay for long-term care if you need it in the future. One of them is a long-term care insurance policy. Another is out of pocket, and the third is Medicaid. So a Medicaid trust is something that can help make someone eligible to use the Medicaid system. In order to qualify for Medicaid, someone must be over 65, blind or disabled, be a New York resident, and unable to perform at least 2 of the activities of daily living, which include bathing, toileting, dressing, grooming, ambulating, transferring, and eating. They have to receive less monthly income than the state guidelines allow and have less than $15,750 in countable resources, which includes cash, stock, CDs, cash value of life insurance policies, and annuities. So one of the ways we can protect assets, become eligible for Medicaid, is a Medicaid trust or an irrevocable trust. The trust is irrevocable, which means once it's set up, the grantor cannot access the principal, but can receive income from the trust. The goal of this trust is to make assets unavailable to pay for care so that you can be Medicaid eligible. It's an effective strategy for protecting assets, and the trustee must act in the best interest of the beneficiary. It ensures your assets will be distributed in accordance with your wishes after your passing, and it can save on income, gift, and estate taxes as well. It also avoids probate and reduces the time and costs associated with administration of an estate. There are also other types of trusts that can be created. There's irrevocable life insurance trust. This is a trust which owns a life insurance policy. It reduces estate tax liability, and the funds are held in the trust for the benefit of those named in the trust. There are special needs trusts. Those are trusts set up to benefit individuals with disabilities. This can ensure that monies are available to help pay for things for the disabled individual, but they won't affect their ability to continue to receive benefits. There are spendthrift minor beneficiary trusts. These protect monies for the benefit of the named beneficiaries. We can also create pet trusts for the benefit of your furry family members. So, what if you don't take advantage of the opportunity to plan in advance? Well, if you don't set up an estate plan, the law says how your estate goes, and it may not be in accordance with your wishes. If you die without a will, the law says who's entitled as an heir of your estate. If you have a spouse and a child, it's both of them. If you don't empower anyone to make decisions on my behalf, someone will be appointed, which if you don't create documents like power of attorney, healthcare proxy, a guardianship someone may have to go to the court to appoint a guardian on your behalf. This involves court involvement, court oversight, cost and expense. And again, the person who's appointed may be an independent guardian, someone you wouldn't want in control of your life. So it's very important to take a look at your estate, to think about creating an estate plan. There's many different options. Wills, you can create a will, you can create a trust. Estate planning documents like healthcare proxies, powers of attorney, living wills can help you appoint those that you would trust to help manage your care while you're living. The will and the trust can help distribute your assets on your death.
Okay. When we look at estate planning, and we look at how do we fund that estate plan? How do we make sure that we don't make any mistakes? When we look at life insurance, when we look at 401ks and annuities and IRAs and pensions, we want to make sure that our beneficiary designations and account designations also are up to date because they affect the transfer in death. With life insurance contracts, annuities contracts, qualified retirement plans, beneficiary designations generally determine who receives the proceeds of the asset. So you may have a will, but who's ever the beneficiary of your life insurance, your annuities, your retirement plans, that's the person that gets the money, not what's in the will. These assets, these retirement assets, will pass directly to the beneficiary who is on that form. As a matter of fact, beneficiary, again, designations will trump that will. So you need to review them frequently, update them when necessary to make sure that certain properties pass to who you want them to pass. Death and divorce of beneficiaries may lead to property passing to unintentional heirs. And I've seen that many a time when people forget to change their beneficiaries and the ex-wife or the ex-husband gets the money, not the new wife or husband. So that's very important to make sure. And other common mistakes that are made in estate planning is not checking your designations on your checking accounts, your savings accounts, your certificates of deposit. So you have to make sure, again, you're checking all of these designations. And when we're looking at estate planning, when we're looking at where the money is going to be, 1 in 5 Americans age 65 or older are still working. And some of them do not have an estate plan. They want to figure out, well, if I do retire, will I have the money for the leisure things that I'd like to do? How do I do that? How do I guarantee that money is going to be there when I retire? We take a look right now, and the market's all over the place. It's up, it's down. If you had money in 2009, a lot of people lost a lot of that money, and all of a sudden the market came back. But people panicked. And when you're looking at retirement, where do I have buckets of money coming in that, and in the estate plan, where do I have buckets of money coming in that I don't have to pay taxes on? There are only 3 things that you don't have to pay taxes on in retirement. You have a Roth IRA, if you have a cash value whole life policy, or you have municipal bonds. All of that money comes in tax-free. Your Social Security is taxed. Right or wrong, it's taxed. You have to pay federal tax on it. And when you're looking at retirement, and you're looking at estate planning, you want to make sure that you maximize your Social Security. So if you were born before 1954, you can retire at age 66, full retirement, but you're leaving money on the table because your full retirement, when you can max out your Social Security, is age 70. So if you wait another 4 years, you get an extra 8% every year. That's 32% more. That's huge. That's money coming in every single month, either at the beginning of the month, the middle of the month, or the end of the month, however it's done. Huge. The other thing you want to look at when you're looking at estate planning is, if I die, how does my wife, my husband, keep the house? How do the children go to college? So one of the important things when you're looking at liquidity is having a life insurance policy. And the cheapest life insurance policy is a term policy. You replace your income, it pays off your debts, it pays for taxes, it's an inheritance equalizer, and it's funds that, if you have a business, can pay for your business and pay off your partner. So that's huge, absolutely huge. Right. Also, when you're looking at estate planning, well, if I have a special needs child, and Christy had spoken a little bit about that, how do I take care of that special needs child? How do I make sure that that special needs child still gets their Medicaid and their SSI? And Christy could talk a little bit more about a special needs trust. I, as a life insurance agent, and also as a retired school psychologist, so I know what goes on with special needs children and special needs adults, can fund that special needs trust to put away for the child, so that the child has oh goodness gracious, somebody who holds the power of attorney, who can then take care of the child. If the child needs to go on vacation, go to the dentist, which is not covered by Medicaid, or needs to buy something, that person who has the power of attorney can take care of that for the child, go out to dinner, whatever, and the child still keeps their money. So that's very important when we're looking at what goes on with children. All right. Some of the other things that, when you look at estate planning, one of the things that you can also do, besides a life insurance policy, a term policy, is put in a whole life policy. Remember I said that whole life policies have cash value, comes out tax-free, and the cash value grows over time. The death benefit grows over time. So that's huge. So there's money coming in that way. So you have your Social Security, you have your pension, you have your IRA, you may have some CDs, which might be good or might not be good. The other thing that we forget about, and Christy hit upon it, is long-term care. Medicare does not pay for long-term care. Medicare can pay for aids in the house temporarily, maybe 2 or 3 times a week for 4 hours. But if you need somebody there 24/7, it's not going to happen. You can do a Medicaid trust, full trust that Christy had mentioned. One of the things that's happening with, and she didn't touch upon it, is community Medicaid, where your house is off the table and some money's off the table, and you can still have lots of money, but you did your Medicaid full trust. And I'll have Christy talk just a quick little bit about that. But the rules on that are changing as of October 1st, and things that we could do now are not going to be able to happen that quickly. So when we're looking at how do we take care of our estate plan, you want to have a long-term care policy. I'll give you an example. My parents did not have long-term care. My mother was on dialysis for 11 years. She had Medicare, original Medicare, and a Medicare supplement. I can't tell you the millions of dollars that were paid out to the doctors, to the dialysis centers on behalf of my mother. My father made sure he paid that bill. He paid for that supplement plan. And all of her dialysis was covered. Not quite covered if you have an Advantage plan. I also sell Medicare, so I'm very passionate about what I do when I work with adults. Right? So when we're looking at estate planning, we're looking at your Medicare, we're looking at your Social Security, we're looking at your life insurance, your annuities, your 401ks, your IRAs, your CDs, and how all of that can come together so that you in retirement can live a beautiful life the way you want to, as opposed to having to worry right now. I'll give you an example. One of the things that we did with my husband's retirement 10 years ago, we put a lot of it into a guaranteed future income annuity. So we took it out of his 401k. We were able to do that because he was over 59 and a half with his company. We put it into a guaranteed future income annuity, and it grows. And when he has to start taking his minimal distribution at age 70 and a half, he's got a big chunk of money that's guaranteed for the rest of his life. He passes away, I get it. I pass away, our children get it, and our grandchildren get it. So that was part of our estate plan. The other part of our estate plan, because my parents didn't have it, is we both have $1 million in long-term care. Will I ever use it? Maybe, maybe not, but it's there and I'll pay for it and be happy to pay for it because I saw what happened. And I talk to clients all the time who all of a sudden decide they want long-term care, and it's not easy to get because life happens, health happens, and they can't get it, and they're up the creek. And then we have to look at other ways of getting them help. Some of that's the Medicaid, if they have a house, a Medicaid full trust, which Christine will talk about a little bit more. All right. So looking at how much money comes in, how it comes in, how to protect it, that's the most important thing, because you don't want to leave money on the table and pay more in taxes. You've already paid enough taxes. Okay? So looking at long-term care needs, looking at Medicare, Medicare supplements, Medicare Advantage plans, RX plans, everything's customized to you so that we maximize your benefits. Christy, you want to say a little bit about the Medicaid pool trust? And
Sure, thank you.
A little bit more about special needs trust.
Sure. So Leslie's talking about the Medicaid, so a pool trust and a regular Medicaid trust are a little bit different. Currently for Medicaid home care, which is where you stay in your home and aides come to the house and assist you with care, the rules allow you to transfer assets and still become eligible for care. That is one of the major things that's going to be changing in October. Currently for Medicaid home care, they look back at your financial picture 3 months. So they'll look at 3 months worth of your bank accounts, 3 months worth of your assets, but they don't penalize you if you were to transfer those assets to make someone Medicaid eligible. In October this year, that is changing, and they are going to begin to create a penalty for assets transferred in 2.5 years prior to the time the person is applying for Medicaid. That's currently the rule for nursing home care. It's 5 years. They look back 5 years at your assets to see if you made any transfers. If you did in that time, you're penalized, and the penalty is you pay privately the cost of your care based on the value of the transfer. What a Medicaid trust can do is start that clock running to protect your assets. So once you put your assets into the Medicaid trust, it starts the 5-year clock or the 2.5-year clock to come. And once that time period has passed, you create a trust. You're 65. You create a Medicaid trust. 5 years go by. At 71, you need Medicaid care. Well, you've passed the 5-year time frame. The assets in that trust are protected, and Medicaid can't look at them. Because for Medicaid, you're only allowed to have a very minimal amount of assets to be eligible. I'm sorry, Leslie, what was the other thing you wanted me to touch
Special
on?
needs trust.
Special needs trust. So one of the other things you can create either through your trust, your revocable trust, or separately is a supplemental needs trust. This is a trust that you set up for someone who may be receiving benefits. Either they're disabled and they're getting governmental benefits. They could be someone under 65. It could be someone over 65, your spouse. Through these documents, you can create a supplemental needs trust that would be funded either on your death or incapacity, or can be done during your lifetime to have a pool of money set up to be used for the benefit of that person who has special needs, but the person themselves can't access it, so it won't affect their ability to continue to receive governmental benefits. But it's another pool of money that you can use to pay for things for them that maybe wouldn't be covered under Medicaid or Medicare or whatever governmental plan, and it can be used to enhance their life without affecting their benefits.
Does anybody have any questions?
Let me see if.
Yes,
oh,
I have a
good,
question.
Go
I have a
ahead.
question. If you do a Medicaid trust, how do you access any of those funds to pay your bills?
So you don't personally, so if I'm the creator, the grantor of the Medicaid trust, why Medicaid allows these trusts is because they're irrevocable, which means you can't change it once it's created, and you as the grantor can't access the principal. However, you can set it up where it directs your trustee, the person you appoint, to manage the funds, and the income. So if you put an asset in there, it's an income producing asset, the income can be paid to you, and the trust can designate what the principal can be used for. So it's an income only trust. You can get the income from the trust, that'll be paid to you. You can use that to pay your bills, or the trust has provisions that allow for the trustee to pay for certain things on your behalf, but not to you, so that you're not receiving the principal of the trust.
Any other questions?
Are there restrictions on that? Let's say I wanted to go to Europe. Could the person who's managing the trust, are they able somehow to get money to fund that, or is it very restricted as to what they can fund?
Well, it's health, education, maintenance, and support. So if you could wiggle it in under those guidelines, then you can use it for that.
Oh, so they can fund. Go ahead.
When you create a Medicaid trust, you're not going to put all of your assets in that trust. One of the big things we generally recommend, and you would also, if this is something you think about, you definitely want to speak to an estate planning attorney. But one of the big things is putting your house in that trust. That's a huge asset, that you have. You can title your house. Maybe some highly appreciated assets, but you have to have funds available to you to live on. So you wouldn't necessarily put bank accounts in there, because there's other strategies that can be done if you had to become Medicaid eligible. to make certain transfers and still preserve some of those assets. So you wouldn't put all of your assets in the Medicaid trust. You would talk to an attorney, see what the most beneficial assets to put in there would be, and you have to then you determine what you're comfortable with keeping for yourself, and you keep some of those assets outside of the trust so you have money to live off of.
Thank you.
Anybody
Does
else
anyone
have
else
any
have
other
any
questions?
questions? Oh, sorry, Leslie, I didn't mean to talk over you.
Any
Let me
other
actually
questions?
end the recording here. Hold on one second.